Hi, I'm Jeannie Posner, and this is the Posner Property Perspective. As a realtor in Metro Atlanta, I've spent years helping people just like you buy, sell, and create homes that truly fit their lives. In this podcast, we'll dive into everything from home flipping tips, healthy home living, to exploring the unique lifestyles and charms of North Metro Atlanta. Whether you're a first-time home buyer, a seasoned seller, or just curious about real estate, I'm here to educate, inspire, and to guide you through it all. Because buying or selling a home doesn't have to be stressful. It can actually be fun. So let's take a fresh perspective on real estate together. And I'll see you at the closing table.
Welcome to the Posner Property Perspective. We're here today with Renee Davis, my favorite closing attorney here in Atlanta. And we're going to discuss what the role is of attorneys in the purchasing and selling process here in Georgia, because it's different in different states. Renee, go a little bit over what happens in Georgia.
So as you mentioned, Georgia's a little different than other states, and really almost every state has their own little quirk and a different way that they handle real estate transactions. Georgia's somewhat unique in that we have attorneys closing transactions. There's only one attorney in the transaction. It's the closing attorney. We represent the lender in the transaction. We don't represent either the buyer or the seller. What I always tell people is that by representing the lender, they have the most at stake in the transaction generally. So if the lender is happy, all of the parties are going to be happy. The only time we do represent parties is if it is the cash closing, if the buyers are paying in all cash, we will, because we have to represent someone in the transaction, we will represent the buyer in a very limited capacity. Most closing attorneys don't litigate. We are closing attorneys because we don't want to litigate. So a very limited representation in the transaction. And again, that's one of the reasons why having a good real estate agent is so important, because in Georgia, especially, that is your personal representative for your transaction.
Right. So you want a realtor who's using what they call the GAR forms, which are the Georgia Association of Realtors forms. They've been reviewed by all the attorneys, and that is why we use those forms. And a matter of fact, if I get a offer and it's not on a GAR form, even if I'm the listing agent, I will rewrite the offer onto a GAR form. So that.
Yes. And kind of unique in that sense too, in that, some states like Florida have multiple different versions of closing or real estate transaction forms that they use. Georgia's nice in that for the most part, everyone does use the GAR form. So it's very standardized. It protects buyers, sellers, their agents. They're modified every 6 months to make sure that they are currently addressing all the needs in the marketplace. You can say a lot of things about the state of Georgia, but our real estate forms are really kind of ahead of the curve in a lot of ways.
They're pretty solid.
Yes.
And one of the big things that you do is a lot of what you do is behind the scenes. So it's checking the title insurance. I don't think a lot of people understand what a title is. If you were going to explain to a buyer, what does title mean?
So I'll kind of explain a little bit more generally, kind of in terms of what the attorneys do. So, your agents are the ones that get you under contract, negotiate all of your terms for purchasing and selling the property. And then once the buyers and sellers come to an agreement, that's when the contract gets handed off to the attorneys. So what we do is we sort of facilitate two parts of the transaction, really. And it's the transfer of title, which is who owns the property, what the legal description is of the property. We make sure that the correct property is being transferred to the parties. And then we facilitate the money portion of the transaction. So all of the money, both the buyer's money, the lender's money, all the funds flow through us. We act as the escrow agent in the transaction. So we're the ones that sort of button up that on both sides. I always say, buyers and sellers, if you don't hear a lot from us, that's probably a good thing. That means your transaction is moving along very smoothly with no bumps. Really, your agents and your lenders kind of do the heavy lifting as far as direct contact with buyers and sellers. Buyers in particular, especially if you are getting a loan, you'll be working much more closely with your lender and your agent than you do with us until sort of near the end of the transaction. We put together the lender's numbers, and then we use all the information in your contract that you've negotiated to put together your sort of final accounting, your settlement statements that we will send out at closer to closing time.
And what is title insurance?
So part of what we do is we examine the legal paper trail of the property. So we make sure that the correct people who have contracted to sell the property are the ones that actually own the property. We make sure that there are no liens associated with the property that need to be taken care of prior to closing. We ensure that everything that does constitute a lien against the property, such as the seller's current mortgages or any outstanding taxes, anything like that, have or will be paid at closing. So title insurance is something that you purchase. It is very different from homeowners insurance. Your lender will, and everyone should have a homeowners insurance policy. Your lender will require that you purchase a homeowners insurance policy, and that protects, that sort of protects your brick and your wood of the property. If your house burns down, your homeowners insurance protects that. What title insurance does is it protects your ownership of the property. What I say is, you buy this one time when you purchase the property, and you really buy it hoping that you will never, ever have to use it again. It defends your ownership of the property against any prior lien holders, against any unpaid liens that the seller accumulated that maybe did not show up prior to closing. It can even help with, one of my most recent examples is a friend of mine went to go sell their lake property, and the potential buyers got a new survey done on the property and realized that the entrance to the driveway to the property was on the neighbor's land. So there was actually direct access to the property from the road to the house. The title insurance company right now has hired attorneys and is litigating that with the neighbor to try to fix that for the homeowner. But really, so title insurance, where it usually comes into play when you go to sell your property, probably about 70% of transactions, we do have the seller send us their owner's title insurance policy, because there is something little on title that an insurance company has already insured over and will agree to insure over again. So as a seller, that means you get to sell your property without any delay, without having to pay anything out of pocket. It's really a peace of mind policy. And I'll say, sort of in the example that I used with the driveway that wasn't it for that piece of property, title insurance is one of those things that if you do have to use it, it's usually over a very large ticket item. It's one of those things that, your policy can vary, your policy premium amount can vary depending on the purchase price of the property. And that is what it's based on. The rates for that are set by all of the title insurance company. They're published rates. You can look them up at any title insurance company's website. We don't have, as closing attorneys, we don't have the ability to change those rates. The title insurance company sets those. In almost every case, the purchase of that premium up front is far less than what you would have to pay in terms of attorney's fees and litigation if a significant problem did come up on your title. And unfortunately, over the years, I have seen many significant problems come up. I personally don't purchase property without getting an owner's title insurance policy, even if I'm the one reviewing the title exam and clearing the title on the property. I've purchased it on all of mine. It's like I said, it's sort of a peace of mind insurance policy. You purchase once and never again while you own the property.
So the two times it's come up when I've had closings, both having to deal with water.
Mm-hmm.
One, the property had a water bill that showed up right at closing for like $6,000.
Yep.
And it went back 3 owners. So what we ended up having to do to close was we had to go back to the last time the seller purchased it, use that title company, and they were willing to insure it continually since they had assured it at the beginning when the seller had purchased it.
Title insurance interesting because it's very different than homeowners insurance. A homeowners insurance premium is based on the risk that the underwriter sees in that particular property. So if you have a property that's never had a claim or, it was of a lower value, a homeowner's insurance underwriter may assign a lower premium value to that. If you've had recent claims on a property, if you had roof damage or, a pipe burst and there was a recent claim, your homeowner's insurance premium will go up and down based on what's going on with the property. Title insurance is not that way. It is solely set on the value of the property. The risk involved, they don't change the premium for what they perceive the risk may or may not be. It's either yes, they will insure the property or no, they will not insure the property, which is why it's so important to purchase a policy when you first purchase the property, because when you go to sell, they aren't looking at the perceived risk to reinsure. They're just looking to see whether or not anyone has covered that already and whether or not it can be reinsured.
Then recently I had an investor who bought a property at the courthouse steps. It showed that there was a $1,700 water bill when they researched it. Ends up there's an $11,000 water bill.
Yeah.
And they are now fighting with that. And it's unclear if title insurance was purchased, because when they first bought it, they bought it with cash. Then they refinanced it. And they're claiming that the company that refinanced it should have bought title insurance. And they're saying, we didn't, because you paid cash for it at the beginning. So it's definitely for that little cost, it will save them a big headache right now.
And so if you are using a loan to finance the purchase of your property, your lender will require that you buy them a title insurance premium. So a lender always requires the title insurance premium. That policy does not cover anything for the homeowner itself, despite the fact that they pay for it on behalf of the lender. What a lender's title insurance premium is it essentially is an owner's premium if they ever foreclose on the property and become the owner of the property. It's their protection. So that is one of the things I always say to people that maybe are thinking about not purchasing a title insurance policy, is that, your lender will not finance this home unless you buy them a policy. And you shouldn't be purchasing.
You shouldn't either.
If you don't want to use the policy. And again, the cost of the premium is often far less than what you would have to spend to defend against a claim. It's a terrible example, but one of my favorite examples for this is a few years ago, someone had bought a condo for $150,000. Now the owner's premium at that time for that was probably around $1,000. Not a huge amount, but a large amount for somebody purchasing
first-time home buyer.
For a first-time home buyer. About 2 years later, they went to sell that condo. And when they went to sell the condo, that closing attorney found that there had been a court order placed against the previous owner, specifically stating that he was not allowed to sell the property and also placed $1 million lien against the property. It had been filed 3 days prior to that buyer purchasing the property.
What?
We had done closing attorneys. We always order a title exam when we receive your contract, and then we always update the title before the closing. The title exam is only good for 30 days. So in that case, we had updated the title 4 days prior to closing. And the lien was filed either a day or two after that. So there was no way that we could have picked it up. The examiner couldn't have picked it up. That purchaser who was trying to sell the property at the time had to file the title claim and let the title insurance company settle up with the seller and the person that had been suing the seller. So it was a huge expense that would have cost them more than the value of the premium that they would have paid. And they had the potential of losing their property altogether.
It's definitely something. Wow. Another thing you have to be careful of is wire fraud.
Yes. So wire fraud has become a huge problem in our industry over the last several years. Just when we think the fraudsters have run out of ways to commit wire fraud, they seem to come up with new and exciting ways to do so. And so what Jeannie and I are talking about here is transactions in Georgia, especially any amount over $5,000 must be wired to the closing attorney or it's not considered good funds. So pretty much all of the money involved in our transaction are wires, incoming and outgoing. So as closing attorneys, we have taken a lot of steps to help prevent wire fraud. we always send out our wire instructions in an encrypted text only. You'll either receive an encrypted text from us, or you'll have to sign into a portal that we have sent you to confirm your wire instructions, to confirm our wire instructions. Never accept wire instructions via email, particularly if it's in the body of the email. That's a really popular way for the fraudsters to try to get the money. And when we talk about wire fraud, generally what happens is a fraudster is hacking into someone's email account, either a buyer's email account, a seller's email account, occasionally the agent's. We see that it tends to happen with more, like the Gmail accounts and the Yahoos, but that doesn't mean it doesn't happen to all of the accounts. And what they do is they somehow can scan the email and pick up on the fact that the account holder is involved in a real estate transaction. So what they will do oftentimes is they will go in and create a dummy email that looks like it's coming from the law firm or from the agent or from the lender, telling the buyer that, hey, these are new wire instructions. You now need to wire all your funds for closing to this account instead of the one you previously received. That is the main way this happens. Like I said, they're always coming up with new ways to commit wire fraud. So we've had it on our end where same thing happens. The fraudsters are going into the customer's email accounts, realize a transaction is going on, and they will send an email that looks like a seller's email to our office and say, hey, we have new wire instructions. We want you to wire our seller proceeds to this account. One way that we've in the industry have been combating this is, agents are very well versed in the fact that they need to talk to their buyers and sellers about wire fraud. The GAR forms that we mentioned earlier, the standard Georgia real estate firms, have the wire fraud warnings, all over them. That's something everyone in the industry is really working to make buyers and sellers aware. And I know our firm, we have specialized software. We run everything through. It's an option called Closing Lock. We have all kinds of software names. So we use Closing Lock, which is a third-party verification system that within 24 hours will tell us if it's a valid account, if it is actually connected to the person who is sending it to us. So, we all do our best to combat the wire fraud and make sure that everyone's money is safe.
I always go over with my clients, 99.9%. The instructions for wiring are not going to change. If you get something that says wiring instructions are changed, do not respond to that. Get in touch with me. I'll make sure with the lawyers because they are not going to change.
And if you think about it from a logical standpoint, if you have ever had to move checking accounts or change your accounts, think about what a logistical nightmare that is, just for the average bear. Businesses, law firms, we do not move our, we establish one account, we stick with it. It is very rare. I mean, I think over the years, in my 25 years of practice, I've had maybe one or two business account changes simply because we were changing software and it was a change at that time that we made. But attorneys are not on the radar changing their account information.
What are some of the things that you see that happen right at the closing table that can almost stop a deal from closing?
I think one of the biggest things is not making sure that inspection items are completed, or a lot of things that, a good realtor will watch out for. Problems that I see with the buyers and sellers that can cause delays are, and this goes back to the wiring, buyers that don't wire their funds ahead of time to the closing attorney. If you're closing it, say 10 o'clock in the morning, really, we prefer that all buyers wire their funds the day prior to closing. Some banks are not as quick to get wires out, even if you're telling them it's for a real estate transaction. And while wires can be fairly instantaneous once they're sent, some banks have, certain processes that they have to go through in order to get the wires out. So I will say a lot of times lack of funds is probably the biggest issue. Some online banks are notorious for offering buyers the option of using a wire or an ACH transfer. Attorneys do not accept ACH transfers. And it's not just that we don't accept them. Our bank rejects them for us and sends it back to the account holder. But unfortunately, unlike a wire, an ACH rejection is not instantaneous. It can take up to 3 business days to get back to the account holder's account. So the ACH issue can stop it in its tracks. So one of the things that we always, try to coach buyers on is make sure that you're sending a wire and not an ACH transfer.
I also, in addition to the funds, we have to go over that you mentioned that everything on the amendment to address concerns, repairs were done, or if items were negotiated to stay. It's always important to go a few days before, make sure all the items were repaired, but then the day of closing to go to the property and make sure everything is okay. I had it happen this year. It was an investment property. The buyer did not get the okay to close for a Wednesday closing until the Tuesday before. It was at 3:00, and the property was in South Atlanta, and it was literally that time of day. It would have taken me over an hour to get there and over an hour to get back. So I said, you know what? I'm going to go tomorrow morning right before the closing. I'll pick up my sign in the lockbox and go to closing. We had a really bad storm that night. I get a phone call at 8:30 in the morning from 2 neighbors going, a tree fell in the middle of the night on the house. And the only reason they were able to call me is because my sign was still there.
Oh, goodness.
The buyer had already done their walkthrough earlier the day before. So if my sign wasn't there, we would not have known until after closing and they went out that there was a huge tree had fallen. So it's really important to do that final walkthrough, because you always hear the stories of the washer and dryer were supposed to stay with the house. And when everyone was moving and no one paid attention that the movers put the washer and dryer on the truck, and you get to the house and the washer and dryer you were expecting is no longer there. So it's really important to do that final walkthrough.
And, these little hiccups that I don't want to say they happen on every transaction, because they don't, but it is not unusual to have things that are really out of control of the agents and the buyers and sellers. Like you said, movers are notorious for taking things that are not supposed to be taken. And the sooner that we can find that out prior to closing, the better. If it's, that last minute walkthrough is really important. But if something happens, 30 minutes prior to closing, or, a few times we have had it happen where the sellers weren't aware that they needed to be out of the house when they showed up at the closing table. That's kind of been a big one the last few years. If you have not executed any kind of temporary occupancy agreement with the sellers must be ready to never come back to the house when they show up at closing, at the time of closing. Some sellers get confused about that, and that can grind things to a halt, if the buyer is expected to move in and, the sellers were not expecting to be out of the house. So, I think good communication with your clients, and Jeannie, you're always wonderful with this, and just communication with the other side and making sure that everyone is on the same page.
And that's what I like to tell people, is that the job of the realtor is to stay calm and to solve the problem.
Yes.
And sometimes I like to solve it before the buyer or seller even know. If I have good communication with the other agent, we can get it worked out before everyone involved has to know. It's like, let's figure out what's going to be the answer. Let's look at it then and get it done. Do you have any last minute, like what would you tell like a buyer to be prepared for or sell at the last minute? I think sometimes it's hard because we do a lot of double closings. And what that means is one buyer, a buyer may be selling their home, taking those funds to buy the next home. And then that seller may be using those funds to buy their next house.
Yes.
And if there's a hiccup along the way, people don't realize that it can affect all the different transactions.
Yeah. So that's something I had noted is, one of the things is you don't always know if this weekend is going to be the weekend that you find your dream house and get it under contract. So when you finally do that, look at, take a moment after being excited and look at your dates, look at your calendar and make sure that all the dates are lining up. When you first went to go look at a house, 3 weeks ago, you may have had a closing date in mind. That may have changed 3 weeks from now, especially once we get into the fall and, school calendars get set, sports calendars, holiday calendars, things like that. What may have been a great date that you were eyeing, 3, 4, 5 weeks ago, once you finally get under contract, may not be the best time. And, again, communication is key. If you see these dates coming up, if something, if you see a conflict, notify everyone ahead of time. The more ahead we can get at any issue, whether it's someone not being able to come to closing or a last minute hiccup, we have much more time to deal with it in a better way, the more lead time we have on.
You talk.
Oh, go ahead.
No, you mentioned about closing, and it's like, so who is at the closing table?
So these days, it depends. Prior to the pandemic, everyone set one day and one time for closing, and everyone showed up, and everyone showed up together, and everyone was there together. And we still do a lot of that. We find now, especially post-pandemic, or during the pandemic, everyone got used to coming at different times. By necessity, we had to come at different times, and sometimes different days, and so some of that has continued. I'd say about half of our transactions, everyone comes to the table at the same time, and buyers and sellers and agents, and everyone signs together. Oftentimes, though, either sellers have already moved out of the state or moved out of the city. So sometimes they're not coming to the closing at all. We're doing, a mail away transaction, which we're coordinating well ahead of time. Sometimes sellers just have a conflict with the closing date, particularly if they're trying to get moved out. So we may sign them a few days early. And it's important for buyers and sellers and agents to communicate all of this with each other so that, when the buyers generally still do come to closing at the same closing time. It's a little more difficult to facilitate mail away transactions if the buyer's not able to come to the table, especially if they have a loan involved. But just making sure that all the information is there at the day and time of closing at the closing table, especially if all parties are not going to be there.
And there's a few things. So one is when everyone's at the closing table, we transfer the keys, if they still have the remotes for the garage, anything like that. And nowadays with all these smart homes, you have to figure out how to get everything reprogrammed. So if everyone is at the closing table, it's kind of a nice time to everyone transfer of information, not just funds, but how does this house work?
It's definitely a little bit more fun when everyone's there because there's a lot more talk about, just like you said, just, like garbage schedules and keys and neighbors and all of that. It can be a fun time for information exchange. And agents are usually pretty good about getting that information from their sellers if their sellers aren't going to be there. But yeah, so, as far as what to expect at closing, everyone may be there. Everyone may not be there. It's really just depending on what all the parties need out of the transaction and what their schedules are for the day.
And I think you mentioned it's easier for the seller to either, if they have to sign ahead of time or to do a mail away versus the buyer. Because I believe, doesn't the buyer have to sign on closing day? If there's a loan?
Yep. If there's a loan, the buyer has to sign the documents on the day of closing. So more often than not, that means that they get to come see us at our office and sit with us and sign. And we make the experience as enjoyable as possible for them.
Well, your new office is wonderful. So that makes it a lot easier. And they have all kinds of nice little suites to make it a more pleasant experience.
Yeah, it is fun. It is fun. Yeah, buyers will generally come in and, sellers too. I mean, like I said, we try to work with everyone, with their schedule, what they need, what is best for them.
And it's important for sellers to remember to bring keys to the closing table. I always get that question. When am I going to get the keys at the closing table? And it's, reminding everyone, bring those keys, bring those remotes so that they can gain access.
Reminder for sellers, hey, get everything together. We see a lot of children selling their parents' homes these days. And for those sellers, it's even more important to they may have to take a few extra steps to get information, for gate codes or, if they're the community association, they may not have all of that information. So just having them gather all that up ahead of time so that so that the information can be given to the buyers is extremely helpful.
And one of the things you just mentioned was homeowners associations. And if you're buying a property that's in a homeowners association, you have to get a letter releasing it, letting them know what the due's been paid, and how that's all structured. And I think a lot of times there can be a fee involved. It's anywhere from like 150. I've seen it as much as now 400 now. And I've seen it where the buyers or the sellers are getting upset with the attorneys about it. And I'm like, wait, they're the go-between. They don't set the price for these letters. They're just gathering the information.
Those management companies are the bane of our existence. Yeah. So Metro Atlanta has a really high percentage of properties that are that do have a homeowners association, a mandatory homeowners association attached to the property. And so what that means is the attorney prior to closing has to get a letter from the association to show whether or not the sellers are in good standing, what the initiation fees are, what the annual or quarterly or monthly fees are. So we have to get an accounting of that. And as you mentioned, those letters can be anywhere from, 150 up to 400. And if there's a rush fee attached, that can add another 150 to 250 to the cost. So if a seller hasn't sold a property in a while, it can be a bit of a shock to them to have to pay for that. And unfortunately, these management companies are very slow to get these letters out, even once they've been paid for. So sellers are required to pay for those ahead of time. And any delay in paying that can delay the closing, since we can't close without those numbers. And I would say, 9 times out of 10, if a buyer and seller are waiting for final numbers from the lender or the closing attorney, it's usually because we're waiting on the numbers from the HOA. Because either the letter hasn't been paid for in time, or it was paid, in the normal manner, and the management company is using every last day to get it over to us.
The other situation that happens with HOAs is when I'm buying, for example, representing a buyer who's buying for a condo, I'll ask for the bylaws and the copy of the last 3 meetings. I want their minutes because I want to see if there's any assessments coming. Has there been any talk about any assessments? So maybe they're not, maybe there's no known assessments, but they're talking about one.
Yeah.
And you can see that in the minutes. And people are always surprised. They're like, why do you need the minutes and this? But again, I want to protect my client, especially a lot of HOAs now are cutting down on the ability to rent properties, or they don't want Airbnbs.
Yeah.
So especially for investors, they really need to look at those bylaws and know what's going on. And they need an updated version, because an investor, I didn't represent them in the purchase. They purchased a group of homes, and it ends up one of them had a change recently in their bylaws, and they weren't allowing any more rentals. And they were referred to me now to sell that property for them. And I've had some agents who've shown the property, and I'm like, you are aware that the bylaws have changed for this community, and you no longer can buy it for an investment. It has to be the end buyer. So it's important to see that.
Point here in Atlanta, because so many of the associations are now prohibiting rentals or severely limiting the number of rentals. A lot of the associations that do permit them have very long wait lists by the current owners to get on the rental list. So yes, if you are an investor, you'll have to do diligence and check that out. The bylaws and the covenants for all the HOAs that are of public record, but more often you're going to have to ask the management company directly or the HOA association directly for a copy of those bylaws. Some of them will post them online. A few of them will. Those are the easier ones to deal with. But I would highly suggest confirm, if you are an investor, or if you are planning to rent it at some point in the future, to confirm directly with the HOA whether or not those rentals are being allowed.
Is there any last minute tip you'd like to give potential home buyers, people buying here in Atlanta?
That's a tough one. Let me think. Yeah, Atlanta is a wonderful place to live. There are so many different communities to look at here in Atlanta. And I would just say, do you look at a lot of different places, find where you're comfortable. As we've discussed here, there's a lot of different communities in the area, some with the HOAs, some not. Everyone has their preferences about their favorite spots in Atlanta to live. But I would say, Georgia's pretty easy as far as the closing process goes. I would say definitely, make sure you're working with a good agent like Jeannie. I would say work with a local lender. The local lenders are much more accustomed to our contracts. They're much more familiar with them. You're not going to run into a lot of surprises with your lender if you're using a local one, and trust your agents. Like they know this city like the back of their hand, and will really help you and guide you through the process and find what's best for you.
And working with an attorney like yourself and your staff is great. And they're just thorough and they're available, and you get a real person, and it really makes a difference. It makes for a smooth and easy closing. Looking forward to a lot more closings with you, even before the end of the year. Hopefully I have a few more coming up. So
Yeah.
Got some listings going on. We'll see what happens. Renee, thank you for joining us today on the Posner Property Perspective. And we both look forward to seeing you at the closing table in the future. Thanks for tuning into the Posner Property Perspective. I hope you enjoyed today's episode and found it helpful as you navigate your real estate journey. Remember, whether you're buying, selling, or just exploring the market, I'm here to help to make the process smooth, exciting, and stress-free. Let's take the next step together. Contact me today. I'd love to hear from you and make your real estate wishes come true. Until next time, take care, stay inspired, and I'll see you at the closing table.